Hi, I am Sahib Shul and my student ID is OED2125. Today I would like to talk about the brief introduction about the case ASICS versus Cosmetics. In 2008, due to financial crisis, some financial limited collapsed. The company was formed by Emil and Julie Cosmetic. Both of them are the executive directors of the company because they hold all the shares of the company and they own them. Few years later, there were few circumstances Essex started proceeding against them in the Federal Court of Australia under Section 181 Corporation Act. They breached the duty of care and diligence. It was alleged that Storm Limited gave faulty advice to its clients, which resulted in these kind of some circumstances. So it was a brief introduction about the case. Now I would like to call my group mates and they will give you further information about the case. Thank you.
Hi, my name is Mohammed Rasi. My student ID is EAB2358. Today I'm going to discuss about the Australian Security and Investment Commission based cosmetics. And I'm going to talk about the brief idea about the breach of this section, the history of relevant storm section breach in this Commonwealth Bank had got involved this money. The reason of that, the creation of the storm and by flip of the owner of the debit duty, which could up to be $88 million from March 2009. This storm plays into the liquidation of the relevant salvation and forensic accounts. Now I'm going to talk about the very important part of this section of the breach. In this section, Section 180 and Corporation Act 2001, and is alleged the breach of this throughout the Section 180 and 181 discuss about the duties or obligation of the Corporation Act 2001. It was apparently directive of this storm, and the main consideration is Josie the cosmetics, which means Emmanuel Cosmetic and Julie Cosmetic had got breach of Section 180. Thank you. Now I'm going to invite my friends to continue the section.
Everyone, my name is Shada Thapa and my student ID is 2569. Now I am going to discuss further say that it shall be mandatory for the directors and the other person officiating as acting in the place of the director in the full factor of the transaction. Commonwealth Bank stressed upon the fact that this portion of the duty was breached most because strong financial use of the delegate this particularly duty to the other factors and business entities. The storm used to aggregate about the critical analysis, it is undeniable that strong financial and its directors did abdicate that duty of reasonable care. Particularly Strom used to interfere very less in the affair of the client, thereby potentially leaving their client at lunch. However, Strom he cannot said to be executed. Now I would like to welcome my friend for the further discussion of the conclusion. Thank you so much.
Hi, my name is Ragini and my student ID is TIA2567. As a result, the court arrived at the conclusion that there has been a breach of Section 180 and 181 by Mr. and Mrs. Cosmetics. On the basis of this decision, it can be said that in view of the duty of Section 180 and 181, the director have responsibility to balance the probable risks of harm being caused to the company as a result of certain course of action, with the burden caused by taking the alleviating action. In this context, harm includes the harm that may be caused any interest of the corporation. It is not required by 180 that this should be proof of real or potential loss to the company. The standard of care that is needed to release the duty of director depends on the circumstances of the company, the position held by the director or the officer, and whatever responsibilities have been given to them. On behalf of our group, I would like to thank for listening our presentation.